Well, hello, Uncivil Law fans. Hope you're having a good day. We are here with probably my last mobile stream, and we're not going to do screen sharing today. So hopefully we will not run into any problems. We've got the Bluetooth audio, which, is not ideal, but at least is a little better because you don't have to deal with the sound of me dealing with the screen. So we've got some Bluetooth audio. So with my Beats, Power Beats thing, and we're going to talk about constitutionality of Act 77 of the Pennsylvania legislature, because we've gotten quite a lot of questions and quite a lot of pushback on this, including from many other lawyers, and I thought we would discuss it and try to amplify or clarify my position and try to at least try to explain it a little bit in terms of where I'm coming from. So that is what we're going to try to do today.
You know the moment when
Excuse
you
me
feel
one
like
second.
you've got life figured out. Work, family.
Sorry about that. Just trying to pull up the chat on the iPad in case you're wondering what I'm doing right now. So I can see the chat. This is the perils of streaming, so that I can watch the chat at the same time. Apparently, I can't do that on this device. That's good news. Watch me struggle with technology as I try to figure out how to do this, so that I can see the chat and stream with you at the same time, without playing with the phone. We will be there in just a second. Okay, well, apparently we can't do that. All right, so we may not be able to play with the chat as much, or we'll have to deal with the sound of the screen, so we'll just deal with it. All right, so let's just go and start with Act 77 constitutionality and try to clarify this issue in terms of the constitutionality of this Pennsylvania Act that expanded mail-in voting and expanded absentee voting and its constitutionality. So there are a lot of people who don't seem to think that I understand how a constitutional amendment becomes law in Pennsylvania. I'm well aware of the process. To do a constitutional amendment in Pennsylvania, you have to have the same bill passed in two legislative acts, and then it has to be put on the ballot for the general populace to vote on. So that it has to be passed twice, and then it has to be put on the ballot in order for people to vote on. Did Act 77 do that? Of course not. It didn't do that. It wasn't written as a constitutional amendment. It is not written as a constitutional amendment. It's written as an amendment to the election code of Pennsylvania. It does not purport to be a constitutional amendment. It is not trying to be a constitutional amendment. It is trying to be an amendment to the statutory text of Pennsylvania. So I am not confused in thinking that Act 77 is a constitutional amendment. I'm not confused in that aspect. I'm well aware it's not. It's just a bill, like any other bill, and all it's trying to do on its own terms is amend the election code. So the question is, can it do that? Is this amendment to the election code constitutional or not, right? So they have just written a standard bill. Act 77 is just a standard bill that just amends the election code like any other bill. And so the question is this new law constitutional or not? And people keep coming back at me with, oh, they didn't follow the process. The process that people keep referring to is the process for constitutional amendments. They weren't trying to make a constitutional amendment with Act 77. They didn't purport to make a constitutional amendment with Act 77. What they said they were doing in their own terms was trying to amend the election code, the statutory text. They weren't trying to amend the Constitution. All they were trying to do was amend the election code. So I'm not confused about the process needed to go through to make a constitutional amendment. I'm not confused about whether or not this is a constitutional amendment. It's not. All it is an amendment to the statutory text. And so the question is that amendment constitutional or not under the Constitution as it existed before Act 77 was written? That's the issue. Now, what makes it Now, what makes it interesting? What makes it interesting is that simultaneously with Act 77 being passed, there was a different law that was also passed called Senate Bill 413. And it's still called Senate Bill 413 because it has not gone into law yet, because Senate Bill 413 does purport to be a constitutional amendment. So it hasn't happened yet because it hasn't gone through that process, right? So Senate Bill 413 was passed by the Senate, passed by the House, but it's still Senate Bill 413 because it purports to be a constitutional amendment process, and it has not yet gone through that process. So what does Senate Bill 413 do? Or what would this proposed amendment do? So it's still technically proposed, even though it's only passed the House, because it's only passed the legislature once, and it has to pass twice and go through it, be ratified by the voters. So what does this proposed amendment do? This proposed amendment would alter the absentee ballot language in Article 7 of the Constitution to essentially allow for no-fault mail-in voting. So Article 7 of the Constitution, Section 14, I believe it is, and I used it as my thumbnail because then people can refer to it and see the exact text of the section. The current section says, the legislature shall grant absentee voting for these four listed reasons. And then it says, and then it's a little bit vague as to anything else. So Senate Bill 413 purports to amend that language to make it open on its own terms. So one could make the argument that the Senate and House have concluded that they have to amend the Constitution, right? Because why would they write this constitutional amendment if they didn't have to? If Act 77 is valid, then what's the point of Senate Bill 413? And one could make the argument, well, they want to, what would be the word? They want to take what is normal legislation. So even though it would be valid for normal legislation, they want to codify that into the Constitution to provide additional security. So you could take this Senate Bill 413 as trying to say, well, we recognize we don't have the authority to do this, and so we need to amend the Constitution, and therefore Act 77 would be invalid because they recognize they need to amend the Constitution, because why else would they do it? Or you could take the view of, we know that we can do it with mere legislation, but we don't think that's good enough. So we're going to do it as mere legislation in Act 77. And also, on top of that, in a belt and suspenders like approach, we're going to elevate this from just normal law, which would be valid as normal law, but we're going to elevate it from normal law into constitutional law because we think it's that important. So even though we can do it as a standard bill, we want to elevate it and encapsulate it in constitutional text. So you could take the view that Senate Bill 413 exists because the House and Senate recognize that they can't do this by mere legislation, which would make Act 77 invalid. Or you can take the view of, no, we still think Act 77 is valid. We just want to make it even more valid by instituting it in constitutional text. So that's one of the ways you could view that. And then, of course, even if the House and Senate think that it's constitutionally required, that doesn't necessarily mean that they're right, because legislatures pass laws that are constitutionally invalid, not infrequently. So, including Act 77 potentially, right? So, and presumably having taken oaths to defend the Constitution of the United States and the Constitution of Pennsylvania, the legislatures presumably think Act 77 is constitutional. But that doesn't, of course, mean they're right. Any more than when Congress passes a law, it means that they're right. The U.S. Supreme Court overturns about 2 statutes a year, give or take, in terms of striking down a statute for federal law. So, Congress is trying to say we think it's constitutional, but at least on the tune of about 2 times a year, they get told, no, you're actually wrong. It wasn't constitutional at all. So, just because the legislature thinks it's constitutional doesn't mean that they're right. And therefore, just because they think it's unconstitutional doesn't mean that they're right either, right? So, it would have to flow. Just because you think it's constitutional doesn't mean you're right. Just because you're unconstitutional doesn't mean you're right. So, If you view Senate Bill 413 as the House and Senate saying we think we have to do this because the Constitution doesn't allow for it, they could actually be wrong in that conclusion. Now, of course, not all, but many of them are lawyers, and they certainly have legislative staff. So, they're all looking at this presumably from a legal angle, but in the same way that they could screw it up by saying, we think it's constitutional, like they passed Act 77, presumably saying, we think it's constitutional. In the same way they could screw that up, they could screw it up by saying, well, actually, no, our Constitution doesn't allow for it, even though it does. So just because the legislature says it's constitutional, or just because they say it's unconstitutional, doesn't mean they're right. Right? You have to go to the courts for that. So you have to look to the constitutional interpretation. Okay, so then putting on my judge hat, I put on my robe and wizard hat, to borrow a famous phrase. Um, I put on my judge hat, and I say, okay, as a matter of law, how do I interpret this? Now, I've made this point before, and I've made it again, that I make a very big point of separating policy from law, right? I make a point of saying this is what I want politically to be true versus what I think is legally correct. So if you asked me if I were a state legislature, would I vote for Act 77? That's a different question to me than saying if Act 77 is passed, was it legal, right? So there's a question of policy versus law. Is this good policy? Is a policy question, and there you can have lots of interesting debates. You can point out, you can cite the various courts that have said that mail-in voting is suspect and it's susceptible to fraud and susceptible to corruption and susceptible to machinations, and it is more susceptible than mail-in voting. And for that proposition, you can find cases from the U.S. Supreme Court, you can find cases from courts of appeal, you can find cases from courts of appeal en banc, you can find cases from state courts. You don't have to look really hard to find citations to cases that say that mail-in voting is particularly susceptible to corruption, particularly susceptible to fraud, particularly subject to manipulations. Now, you could still say it's worth it in the end from a policy perspective because you're trying to balance out policy considerations. So maybe it is more susceptible to fraud, but it makes it so much easier for legitimate votes to come through that the amount of new legitimate votes that would come through will dwarf any potential fraud. So even though it's susceptible to more fraud, the benefit, so that would be a cost, right? So it's and this is arguments you could make, not arguments I am making. These are arguments you could make from a policy perspective. You could say, okay, it is more susceptible to fraud, it is more susceptible to corruption, it is more susceptible to manipulation, but we're going to gain so much ease of access for legitimate votes to come through that the amount of new legitimate votes will dwarf any potential fraud, and therefore, from a cost-benefit calculation, it's worth it. Right? So that's an argument one could make, not that I'm necessarily making. But these are policy considerations. Like, is it worth it? What is the risk of fraud? How much is the risk of fraud? How many more legitimate votes are we going to get? Is it okay to have some fraudulent votes if we get way more legitimate votes? Is that a thing that makes sense to do? And you could argue that either way on a policy perspective, right? So these are policy arguments. You know, should we have signature checks or not? Should we require signatures? What does that mean if we don't have signatures? What does it mean if we don't have signature verification? How much more fraud or how much more corruption versus how much more legitimate votes are we likely to get? Should we allow ballot harvesting? What is the threat profile from that if we do that? Is the benefits that we would achieve from that worth the cost of whatever threat profile? And so forth and so on. So you can make these various policy arguments if you're looking at it, is mail-in voting a good idea, right? So you could make arguments for and against it, and you could say, well, it's not that much fraud. We're getting so many more legitimate votes. Or you can make the argument, it doesn't really matter how many legitimate votes we're getting. Fraud is fraud, and fraud is bad. So, you can make arguments one way or another, but those are policy issues as to whether or not you want mail-in voting. I'm not really here to do policy for the most part. I do law. Um, I do law. So I put on my legal hat and I simply say, okay, whatever the policy arguments are as to whether or not this is a good idea. The legislature has passed Act 77. The governor signed it into law. So my question to myself is, was that legal? And in order to answer that question, what I do as a judge, or hypothetically as a judge, or what I would do as a judge, is I take a look and I say, okay, what are the provisions in the Constitution? Because we're saying it's unconstitutional under Pennsylvania law is the argument. What are the arguments? Oh, my hands are shaking pretty bad. I'm sorry. Sometimes I get tremors in my hand, so I'm sorry for the shakiness. But sometimes I get tremors in my hand. It's usually not a big deal, but sometimes it pops up. So you'll have to forgive me. Sorry for the shaky cam. I'm on mobile. I'll be back at my studio tomorrow, so we won't have to deal with these problems. But I wanted to record a video because I was thinking about it and wanted to share my thoughts on this. Anyway, so as a judge, I say, okay, is this constitutional? And so I look at the constitutional text as it exists, because again, Act 77 did not amend the Constitution. It doesn't even purport to amend the Constitution. It doesn't try to amend the Constitution. It is not a constitutional amendment. It is just an amendment to the election code. Period. End of analysis. It is not a change of the Constitution. So the question is Act 77 constitutional under the Constitution as existed at the time, or continues to exist because it hasn't been amended in this respect? So to answer that question, I take a look at the code, and I've taken a look at the code, and I'll just pull it up real fast on this iPad because I can do that at least. I can't pull up the comments on here, but at least I can pull up the Pennsylvania Constitution and read it along with you. I can't put it on screen, but at least I can read it. So, and I'll show you the legal analysis that I'm doing. And I'll show you how I think about it. And you can, take it for what it's worth, whether or not you think this is good reading or not a good reading. But I'm going to explain it to you like I'm a judge, right? I'm going to say, here is how I'm interpreting this. I'm going to explain it to you like I'm a judge. I'm going to give you my legal reasoning, and it'll either be persuasive or not. So that's okay. So we need to go to Article 7 of the Pennsylvania Constitution, which I will pull up. I do not want to use your mobile website, as a matter of fact. I just want to use the regular website. Thank you. All right, so this is Article 7 of the Pennsylvania Constitution if you want to read along at home. All right, so let's read some various provisions in Article 7. Number 1, every citizen 21 years of age, and that, of course, has been amended by the U.S. Constitution, but it hasn't been changed in the Pennsylvania Constitution. It still says 21. But, of course, the 26th Amendment, by federal law, changes it to 18. But anyways, in the Pennsylvania Constitution, it still says 21. Every citizen 21 years of age, possessing the following qualifications, shall be entitled to vote at all elections, subject, however, to such laws requiring and regulating the registration of electors as they may enact. So it says every citizen who's of voting age is entitled to vote at all elections, subject to registration requirements, but they're able to vote in all elections. So there's a presumption of the ability to vote, right? Then in Section 4 of Article 7 of the Pennsylvania Constitution, it says all elections by the citizens shall be by ballot or such other method as may be prescribed by law, provided that secrecy in voting may be preserved. So Section 4 says all elections shall be by ballot or by such other method as may be prescribed by law. Any other method, as long as you're preserving secrecy, right? So you can do it by ballot or any other means. For example, mail-in voting, maybe? I mean, it says you can provide for other methods in Section 4, right? Okay. And then we get down to Section 11, which is or Section 14, which is the one I made the thumbnail of because it's the principal section that is at issue here. And I'll read it. And I'll read it the way I would explain it if I were a judge. The legislature shall by general law. Okay, so that's just a bill, right? The legislature shall, by general law, provide a manner in which, and the time and place at which, qualified electors who may, on the occurrence of any election, be absent from the municipality of their residence because of their duties, occupation, or business requires them to be elsewhere, or who, on the occurrence of any election, are unable to attend at their proper polling places because of illness or physical disability, or who will not attend a polling place because of observation of a religious holiday, or who cannot vote because of election day duties in the case of county employees, may vote and for the return and canvass of their votes in the election districts in which they respectively reside. Right? So that's the language of Section 11, which I made the thumbnail of so that you could go read it yourself. And so here's how I read that. Here's how I read that as a judge. Okay? Because I'm trying to interpret this language. What does this mean? So let's put on my judge hat and try to look at this. Okay, so my baseline as a judge is I'm an originalist and a textualist. And I lean a little bit more onto the textualism side. And the difference for me between originalism and textualism, at least to me, and what those terms mean, because they mean different things to different people. Textualism looks a lot more at the literal text on the page and doesn't really consider other factors. Originalism looks at the original text on the page and factors in more about what various terms mean or history or things like that to find out the original public meaning. So textualism is a little bit more divorced from public meaning and looks a little bit more just to what do the words on the page say. So there's some nuance in there. Because they kind of both are looking at same things. It's just one, at least to me, reads a little bit more on the black and white text, and one looks a little bit more to the meaning behind the text. So that's a textualism versus originalism approach to me. So I consider myself an originalist textualist, or maybe a textualist originalist, because I lean a little bit more on the textualism. All right, so how do I interpret this as a textualist? And just looking, so I'm doing a Justice Gorsuch. That's what I'm doing. I'm doing a Justice Gorsuch, or at least in my own mind, I am. I'm doing a Justice Gorsuch because I don't know that I can play on his ball field. He's smarter than me, but I'm trying to channel some Justice Gorsuch. All right, so how do I interpret this as a potential judge and trying to interpret what this language means? Right? Okay, so the legislature shall. So that's a requirement. You must do stuff. Right? You, the legislature, must do stuff. Whatever else you can do, whatever else you're empowered to do, whatever else authority you might have, right? You might have authority to do many things. You may have lots of choices in this world. But whatever other freedom you have, you must do this. Great. You shall provide a manner in which, at the time and place at which, qualified electors who may, on occurrence of election, be absent, and then it goes on to specify what those things are. So it goes on to specify what those things are. So then this comes down to, as Robert Barnes put it, and I want to publicly thank him again for his very kind words to me, or at least his kind way of addressing me on Viva's channel. I really, really appreciate it. It was very deftly done, where he brought up my interpretation, and he brought up my point, and he didn't strawman it, and then he just disagreed with it, which is fine. I don't mind disagreement. He disagrees with me. You know, in terms of the internet commentariat, I'm kind of running alone on this one so far. So my interpretation disagrees with Robert Barnes' interpretation. It disagrees with Nate Brody's interpretation. It disagrees with Nick Reccietta's interpretation. So I'm, kind of running a interpretation of one at this point. So, I have dissented with my fellow colleagues on this particular issue. So the majority consensus appears to disagree with my interpretation. But that's okay. We can have legitimate disagreements, and I appreciate the way that he did it. He very thoughtfully mentioned me in a very kind way, and he didn't strawman me and then proceed to disagree with me, and that was very nice. So anyways, I look at this language and I says, okay, so I'm looking at this from a straight textualist perspective, maybe a little less on the originalism. And it says, okay, the legislature shall provide a manner at which qualified electors who may, on occurrence of any election, be absent because of these varying reasons. So you have to provide, it's the way I read it, it says you shall provide for qualified electors who may be absent from their municipality because of, and then listed this reason, this reason, this reason, this reason. So it lists 4 reasons. So the question is that a ceiling, or is it a floor, or is it both? Right? So is that a minimum? Is it a maximum? Or is it both minimum and maximum? Right? So that's where I am splitting with Robert Barnes and splitting with Nick Recchietta and splitting with Nate Brody. Right? They disagree with me. I say, well, this language to me strikes me as a floor. You have to do at least this much. The the legislature in Pennsylvania has general power to do stuff. They have the general police power. They have the general power to pass laws that regulate conduct within the Commonwealth, right? So they have the general police power. And then the Constitution says, okay, even though you have that general power, you shall do this. So you must do this. But it doesn't say, and I don't read it as saying, you can't do other things, right? So I say, oh, this is a floor and not a ceiling. You, the legislature, shall provide for absentee voting for this reason, this reason, this reason, this reason. And so it doesn't go on to say, well, what about other reasons? It doesn't say anything that would, at least on its own terms, there's nothing in the text on its own terms. There's nothing in the text that says these reasons and only these reasons, or absentee voting only for these causes, or only, there's nothing like that in the text of the language, right? It's just not there. It just says you shall do it for this reason, this reason, this reason, this reason. And it doesn't say anything about other reasons on top of that. You have to do it for at least those reasons, but the question is it at least those reasons or only those reasons? That's the dispute that we're having. And I interpret it as, and I'm trying to approach this as an originalist, I'm trying to approach this as a textualist, I'm trying to approach this as a conservative interpreter. Again, this isn't about my policy perspectives. It isn't what I wish would be true. It isn't about, do I think this is a good idea? It isn't about, do I think this is wise? Or any of those things. Because I, as a judge, don't ask those questions. Those are policy questions. I don't do policy. I do law. The legislature has, for better or worse, passed Act 77, which, again, to say it again, because I know people will bring this up, I keep repeating it because I have to keep mentioning it. Act 77 is not an amendment to the Constitution. It doesn't purport to be an amendment to the Constitution. It is not an amendment to the Constitution. It is just an amendment to the Election Code. It did not go through the process to make an amendment. No one is confused about this. It doesn't try to be an amendment to the Constitution. It didn't go through the process to be an amendment. It is just an amendment to the statutory text. So can they do that in light of this language? And my answer is yes, they can. Yes, they can. Because this language is, you shall do this much. And, the way that I sort of think about that, and you can think about how language, or whether things are upper limits or under, whether things are caps or floors or ceilings or both, right? So, like, if you see, there's a lot of different examples you can use to illustrate this. But if you see a sign that says speed limit 65, and you didn't know because you're not familiar with driving, so you don't know what it means. If you're just trying to interpret it in the dark because you don't have experience with driving, you see speed limit 65. Okay, is that an upper limit? Is that a lower limit? Or is it both? Is it saying you have to go at least this fast? The speed limit is 65. You must go at least this fast or faster. Is it saying the limit is 65? You can only go this fast or slower? Or is it both? You must go exactly 65. So when you say speed limit 65, is that an upper limit? Is it a lower limit? Or is it both? Now, you and I both know from our experiences in reality that is in fact an upper limit. But the term by itself is ambiguous because it's a limit in like a mathematical sense of limit. So are we talking about an upper limit or talking about a lower limit, or is it both? We know, as a matter of fact, it's an upper limit, but it's not clear from its own text. And then, you can think about this from a position of how this might manifest in other relationships. So you wouldn't normally use language like shall or must. In a familial relationship, you'd use other language, but because that language is a bit harsh. But if you told your kids, if you told your kids, before you can go out and play, you must, I don't know, you must do your homework. All right, so before you go out and play, you must do your homework. You wouldn't normally phrase it that way, but that would be the sentiment. All right, does that mean that you can't do other things beyond? You shall do your homework. Is that telling you that you can't do other things? So is that telling you that you finished your homework and then you must go outside because you have no choice? So if you said to your kid, you shall do your homework before you go play, is that an exhaustive list? So, I mean, the kid could presumably, do their homework and then go outside. There'd be nothing wrong with it. They'd be following your command. But if they chose to do their homework and clean their room and do their chores and do other things before they went out to play, would they be complying with what you said or not? Right? So you must do your homework before you go out and play. You shall do your homework before you go out and play. Are you saying that's an upper and lower limit, your homework, and then go out and play? Or are you saying you must do at least this? And if your kid, for reasons that, pass comprehension, not only does their homework, but cleans their rooms, does their chores, takes out the trash, and then goes out and play, would you say that they defied your command? To me, the answer is no. I wouldn't say that they did. They did what they had to do to go out and play, and then chose, because they're conscientious, to do other things on top of it. So the command, you shall do this, doesn't, on its own terms, seem to indicate you can't do other things. It says, well, you shall do this much. You're generally free, but you must do this. It's a constraint on your freedom. And if you want to do other things, that's okay too, right? So that's sort of what I think about all that. So that was a lot of explanation to try to explain my views on this act. The act, again, just to recap back, to go to the top before I take some Q&A. Act 77 does not purport to be a constitutional amendment. It is not a constitutional amendment. It did not go through the constitutional amendment process. I am not confused about this. I completely understand that Act 77 is not a constitutional amendment. We're all very clear. It just amended the election code without amending the Constitution. 100% clear. The question is that constitutional? And then you could also, as I mentioned before, look at Senate Bill 413, which has been passed, but only passed once, which Senate Bill 413 attempts to amend the very constitutional provision we were just reading. So Senate Bill 413, which has been passed once, but hasn't gone through the full process yet, attempts to amend Section 7, Section 14, to make the language more open. So it's trying to amend it, and it hasn't done it yet. Is that because they thought they had to? Is it because they thought it would just be a belt and suspenders? Like, we think we can do this in general legislation, but we think it's so important, we also want to do it in constitutional. So strictly speaking, we don't have to. We just want to because we think it's that important. And even if they thought, well, we had to, does that mean they were right? Because legislatures sometimes make mistakes about what's constitutional, what's not constitutional. So even if they were saying, well, we think we have to do it, were they right in that conclusion? Right? Because they made an assessment, but ultimately it's for the judiciary to decide what is and is not constitutional. So even if they thought that they had to do it, doesn't necessarily mean they were right. So, but that's where I look at it. I take a look at the text. It says the legislature shall provide for absentee voting for these listed reasons. It doesn't appear to, on its own terms, prevent other reasons beyond that. There is a provision in the Constitution that we read earlier that says that people have a right to vote by ballot or other means as the legislation may direct. Presumably, this would be other means. So the language, at least is the way I'm interpreting, appears to allow for it. So you can criticize that analysis because other people have criticized that analysis. Nate Brody criticizes that analysis. Nick Riccietta criticizes that analysis. Robert Barnes criticizes that analysis. They think the better interpretation is that it's both an upper and lower limit. So we have a dissenting opinion. So in our little en banc panel that we've got going on so far, we've got a 3-1 decision, right? So I'm in the minority over here on our 3-1 en banc. I'm like, that's okay. Courts don't always agree with each other. Judges don't always agree with each other. I've tried to interpret this as I see best. I understand their argument, so I'm not like super mad about it. I'm not like salty about it or anything like that. So, if I were writing this as a dissent, I'd be writing I respectfully dissent because I do. I just don't think that's the best reading. I understand that reading. I just don't think it's the best reading. Robert Barnes has some ideas about how he looks to older versions of the Constitution. He looks to some skepticism with mail-in balloting, and he goes what I would frame as a more originalist interpretation, as opposed to my more textualist interpretation. So that makes sense. And some of the other people have arguments that make sense too. I just don't happen to agree with it right now. So hopefully some of that was helpful. Yeah. Right. Nate the lawyer says supermajority. That's right. Yeah. So yeah, supermajority. Yeah. So we got a 75% vote. Nate the lawyer is killing me over here. I'm giving Nate the lawyer. I'm giving Nate the lawyer all the love and credit in the world, and I'm saying, yeah, they disagree with me. Here's why they disagree with me. You know. And then he comes back at me with supermajority. Giving me some back chatter. That's funny. I love you, Nate. You know that. All right. So let's do some response to chats. Yeah. Yeah, so let's I'm going to scroll back up as far back as I can scroll up and try to do some chats. So, I will get back to you guys. So we're going to scroll back up to 12 o'clock, which was what, a half hour ago? Yeah, so let's go back a half hour ago and we'll respond to some chats and we'll see where we go from there. Watching You Daily says it's unconstitutional. Could be. Yeah, then that says there's other issues too, like the equitable issues with latches. There are other issues too. But like, yeah, standings are issues, latches are issues, and courts always try to look for the easiest ground. Like they try to look for the easiest way to solve the problem. So them solving the latches made total sense. I just like, okay, let's just deal with is it constitutional? Let's avoid the standing issue. Let's avoid the latches issue and just go to the constitutionality issue. I'm like, yeah, I think it's constitutional. I did not see the Scottish census case today. No. I understand it is an amendment. It seems to have the effect of an amendment, though, doesn't it? Not the way I interpret it, but that's my view. Yeah, I got some Bluetooth headphones. I got some Beats, so they're not so bad. The election thing is a bit of a mess, yes. Pennsylvania is notorious for not following its own constitution, whether its taxes are eminent domain. The Supreme Court will have to step in as justices are 100% Democrat. Well, as I understand, it's 5 Democrats and 2 Republicans. But, just because a Democrat says it doesn't mean it has to be wrong. Like, Democrats can occasionally say things that are correct. So, just because a Democrat would agree, or just because Democrats would agree with my position, presumably for illegitimate reasons, doesn't mean that for legitimate reasons I don't disagree. So I might disagree. I might agree with them for other reasons, but I agree ultimately in the outcome. So, yeah. I'm trying to deal with the chat, and on this mobile device, it is really a problem because I keep losing the chat in place. So I'm gonna have to like keep my finger on screen or something, and it's gonna be problematic. I didn't see the lunar eclipse. No, it was cloudy last night in South Carolina, where I'm still visiting my parents. Nice jacket, thank you very much. Are your parents looking at here from inside the house? There he goes on YouTube again. A little bit, yes. Afternoon, hello. Yeah, I didn't see the lunar eclipse because it was cloudy last night in South Carolina. It does not look like Austin because it is not. I'm in South Carolina right now. I love Rakita's take on law, but I really dig Uncivils as they're very different approaches. Love the videos. Keep it up. Thank you very much. Do states have separate constitutions on top of the U.S. Constitution? Yes, they do. Hildred Scott, yeah. Why are Pennsylvania textualists not textualists? I couldn't speak to that, but I'm just speaking it. So by your reading of it, it only applies to electors, not voters. I think the way that they're using the term in this section is referring to voters. By electors in this context, the way that I'm reading it, they use the term electors, but what they seem to be meaning is voters. So they're not referring to electors in electoral college, no. They're referring to voters, as best I can tell. Um, Barnes takes originalism, says the intent of 77 was be ceiling, not a floor. Yeah, right. That's exactly what he says. He takes a more originalist point of view. He says that was the originalist intent. And he may or may not be right. And I take a more textualist view. And so that's probably why we're splitting. That's okay. Interpretation one is story of your life, yeah. Barnes stated previous laws that have influenced the creation of absentee vote. Yeah, that's right. That's what he did say. Isn't a constitution a document of enumerated powers that only authorizes what's enumerated? It can be, it doesn't have to be, right? So in the context of the US Constitution, you have that as enumerated powers, yes. So that is the understanding of the US Constitution, but it's not necessarily the understanding of any particular state constitution. So that's a valid idea. I just don't see it particularly right now. So that'd be true for the US Constitution, not necessarily true for all constitutions. And also because another reason that this is true, incidentally, in state constitutions where it isn't true in federal constitutions, the reason why there's a very important reason why the federal constitutions list of powers in Article 1, Section 8, for example, where it lists the powers of Congress to do stuff. There's a very important reason why that is perceived and interpreted to be exhaustive, whereas the list in Pennsylvania would not be interpreted to be exhaustive. So there's a very, very important reason, and that is because the federal government does not have general police power, right? So the phrase police power is a bit misleading because when you hear the phrase police power, you think about police, you think about the cops, but that's not what the phrase means. When you talk about police power, what that phrase means is the power of government to do stuff, all the stuff, all the things is police power. It's the power of the government to regulate and pass laws in every possible domain is police power. The federal government does not have police power. So therefore, when you look at the U.S. Constitution, you say, oh, this is exhaustive, this and nothing more, because they don't have the general police power, as opposed to states that do have general police power. So the way the constitutions work between states and federal, right? The federal Constitution says, and the 9th and 10th Amendment also reflect this in the text of the Constitution itself. So you know I'm not just making it up. It's also 9th and 10th Amendments of the Constitution. It says this list is exhaustive. This is all the power federal government has. They don't have general police power. All remaining power, all the police power belongs to the states. So when you look at the U.S. Constitution, you look at Article 1, Section 8, you say, okay, this list is exhaustive because the 9th and 10th Amendments say so, and also because the federal government doesn't have general police power. States do have general police power. So when you look at this in the Pennsylvania Constitution, you say, oh, these are only limits on the police power. So because general police power is the power to do everything, the general police power is to do all the things. The state constitution can only limit that power. You know, it can't grant power because the power was there in the first place, right? That's all the police power. All the police power belongs to the states. So the constitutions of the states can only restrict the police power. It can't grant power, as opposed to the federal constitution, which does grant power. So that's the distinction. The federal constitution grants power where otherwise would not exist. There would be no federal government but for this. There would be no power of Congress to do stuff but for this. So the federal Constitution, in its text, not to refer to the amendments, but the text of the Constitution, not the amendments, the Constitution itself, is power. It's grants of power, but it's limited grants of power. It's not general power. It's limited power. So here is some limited power, this and nothing more. And then on the state level, you have all the power. And then if you want to limit yourself in your constitution, you can do that. So you would interpret state constitutions without more. You'd interpret it as only providing limits on police power. So if the general presumption is the states can do whatever the hell they want because they have all the general police power, they have all the power of government, they can do anything they want. And then you come up with a clause in the Constitution of Pennsylvania that says, oh, by the way, you shall do this. It's like, oh, okay. Well, you had the power to do anything you wanted. And though you have the power to do anything you wanted, you must also do these things. Great. Fantastic. I must do those things. And even though I must do those things, I still had general police power. So yes, I must do that. But if I have general police power, I can do anything else I want So yeah, I have to do that, but I only have to do that. And if I want to do more, I can, because I'm free. I can do whatever I want. I have all the power. I have the police power. I have the big hammer of government. I have my big ass hammer here, and I can beat down with all the power of government. Because I have the police power. And then it says, oh, by the way, you must do this, government. All right, great. I must do that, but I can do other things. So that's exactly why, to me, you interpret that differently in the federal and state government. It's because of that police power. The presumption is the federal government only has the powers that it has. It does not have general police power. The state governments have general police power. Therefore, you interpret the constitutional provisions as only limits, not grants of power. That's exactly what I think, and that's why I interpret that way. Where was I? Let's see. A lot of people have their own interpretations of law and how it appears. If no, would you not have different opinions? Yeah, exactly right. Even the Supreme Court disagrees with each other sometimes, right? You get 8-to-1 opinions, and sometimes I think the one was right. So we've had 8-to-1 opinions where I've agreed with the one. Can we talk about Kansas v. Glover again, where it was me and Justice Sotomayor on a raft alone? 8-to-1 opinion. Did I agree with the 8? No. Did I agree with the 1? Yes. Who was Justice Sotomayor? Yes. I thought she got it right. It's me and Justice Sotomayor in a raft alone. I'm not sure what it says that Justice Sotomayor, who at this point on most scaling would be thought of as the most liberal justice, because there are different ways you scale this. So Justice Sotomayor is probably the most left-leaning justice on the court at this point. So I'm not sure what it says that it's me, a conservative, and the most left-leaning justice who agree on this particular issue, but whatever, that's where we are. Yeah, someone said that isn't how the U.S. Constitution is interpreted, and I pointed out why. In PA, you'll get a ticket if you use that logic, maybe. 25 HR Krona. That's Croatia. You shall clean your room and kitchen does not mean you're barred from cleaning the bathroom as well. Exactly right, Barney. Yeah, that's what I'm saying. So thank you for the 25 Croatian krona. It is appreciated. What about the U.S. Constitution? It says state legislature will enact the laws that govern elections. If for absentee ballots, you have to have an amendment. Does that mean the legislature alone doesn't decide? Yeah, that's part of it too. And I think that the text of the Constitution, where it says the legislative has power, I think it's best understood as being part of the legislative process, or not. So I don't interpret it. So that's one where maybe it's more originalist. So that's one where I'd go more originalist rather than textualist. So my loyalties between originalism and textualism are being challenged, because I think that when they were writing that particular clause, they were speaking to the fact, if when the Supreme Court of the state is interpreting the state's legislation, I think that's still a valid exercise of legislative power. But yeah, that's if you want to say that's a conflict between originalism and textualism, and I can't pick a side, well, you might have a point. But I did say I lean more on textualism, not hardcore textualism. So that would be one where I'd take a more originalist approach. So yeah. What earthquake am I living through? I'm living through the fact that it's a little cold outside and my hands are shaking. If you don't play, you don't have to do homework. Yeah, that too. Nathan Lure says, what about the standing issues? Nathan Lure is completely right. There are a lot of standing issues. We kind of ignored the standing issues to get to the root constitutional issue. So yes, there are standing issues. Yes, there are mootness issues. Yes, there are laches issues. And unlike Robert Barnes, who apparently thinks that in 1922, the Supreme Court engaged in some sort of mass interpretation error or something, I think that those are valid doctrines. We just kind of ignored all those issues for the purpose of having the underlying constitutional analysis, because I'm not actually a court, so I don't actually have to do those things. because I'm not actually a court, I get to focus on the issues I want to focus on. It's like, yeah, I'm going to focus on the constitutionality issue. I'm going to have a fight about that. 1A is not an enumerated power of government. Yeah, it's a restriction on the government. That's true. Which is why I was pointing out it's in the text of the Constitution versus the amendments, right? If you want people to believe you or be convinced of your argument, it's helpful to at least be looking at them sometimes during it. He does know this information, right? Yeah, but someone was asking about eye movement and cognitive process. So there's some great papers on this. But yeah, when some people think, their eyes move because it reflects underlying changes in their brain activity. So there's some great papers on this. You can just look up eye activity, brain activity, and the link thereof. There's some great papers that point this out, that some people, when they think, their eye movement, because their eye movement is reflective of changes in their brain. And so like it can represent like cross hemisphere thinking or things like that. So like sometimes when you're thinking and accessing different parts of your brain, your eyes move as a sort of a reflex of that. So yeah, I wasn't looking at the camera because I was looking up when I was thinking. So my eyes were up here as opposed to looking at you because it makes it easier for me to think, or at least it's harder to control that response. You can do it with effort, but the atomic response is because I was thinking. So sorry for not looking at the camera, but I was actually thinking, and so it wasn't meant to be. Someone was chastising me on this in the comments recently. It's like, why are you always looking to the right? Why are you always looking? It's like, because I'm thinking, and I'm one of those guys that when I think, my eyes move because I'm thinking. U.S. Constitution says there will be a president. Doesn't say there can't be more than one president. Well, the term "a" is singular, so it says the power of the executive shall be in a president. So if you had more than one president, that would defy the singular text. But feet is a touch of epilepsy. Sorry, man. It's cold. It's cold, and my hands are cold. And I'm doing very good. I'm trying to do the best I can. I'll be back. I'll be back at my computer tomorrow, and we won't have to do that. We don't have to deal with the shaking. It's just I was thinking, and I want to share my thoughts. So, and I don't have a tripod, so we're dealing with what I can. So, sorry about that, but I wanted to share my thoughts on this because a lot of people were asking me, and it's very chilly out here, and I'm cold. I would argue it's unconstitutional. The voting code is unconstitutional because it says in the Constitution it must be made alter by law. A code is not law. It's code, like code of honor. Well, as to that one, my friend, you're wrong. We use the word code to mean law. You can look at the U.S. code. We don't mean code in the sense of code of honor. When we use the word code, we mean the word code here is an extension of the word codified, and which is law. So when we say something is code, that's law. So that one you're just wrong on. Yeah, a code is not law. Code is in fact law. It's codified law. So you can have law that's not codified. You can have law that's not in the code. But things that are in the code are in fact law, at least in the sense we're using them. So that one, no. Rocky Power says, I guess he's obviously not interested in reading any type of questions or interact with live today, but that's fine. I'm interested. I just went back to the beginning of the chat to try to get back to the things that I skipped. And so I'm like a half hour behind, Rocky. Give me a break. I have a choice between responding to things in real time or going back to the beginning of the chat and trying to respond to all the things that I missed along the way. And I went with option 2, going back to the beginning and dealing with all the things I missed along the way. So I'm obviously interested in reading or interacting. It's just I'm behind. So give me a break. Jeez. He's on mobile. He's going through them right now. Yeah, he does. Yeah, so I'm trying. Yeah, and for some reason I couldn't get the chat up on the iPad, so we're dealing with this because we had problems. I think latches is lame, even if there's a latches issue, should decide constitutionality. Fair. Yeah, I don't particularly blame the court though, because courts tend to look for the easiest ground possible, and so that makes sense at least. But yeah, that's why I kind of ignored those issues for today's discussion. It's like let's ignore all the latches standing, and let's ignore all that stuff and just go to the root issue of is it constitutional or not, because I think it'll be interesting. Yeah, I unfortunately I couldn't get it up on iPad today. Rocky says he looks like he's talking to someone live now. I guess he can review them and look at them as well, which makes it sense. It's probably difficult to do both. I'm doing the best I can, man. My understanding of U.S. and state constitutions is their enumerated powers. No, I disagree with that. The U.S. Constitution is, state constitutions are not, as a general rule, because the Ninth and Tenth Amendments make clear all the power not granted to the federal government is reserved to the states. So the federal Constitution says all the power not given to the federal government is reserved to states. So the states have police power in the first instance. Yeah, Nate says Barnes is wrong. Standing is a fundamental piece of law. I agree with Nate here. Yeah, standing is a fundamental piece. We're just ignoring it for today because I thought we'd have the constitutional discussion. So we're ignoring those issues for the moment. So, as a textualist, as the meanings of the words change, does that change the meaning of the Constitution? No. No, you'd still interpret the law. You'd still interpret the words what they meant at the time. So you'd still apply the meaning as it is. You just wouldn't look beyond that to say to purpose or intent or that kind of thing. So I think originalism factors in a little bit more of original purpose, original intent, and textualism. No, it doesn't take modern definitions of words. It looks at the old definitions of words, but it takes less consideration of intent and purpose than originalism does, or that's at least the way that I think about it. Reasonable people can disagree. That's exactly right. Reasonable people can disagree. Even reasonable lawyers can disagree. As Nate and I disagree, and Nick and I disagree, and Barnes and I disagree, and I'm on a mission of one over here. That's okay. Yeah. Nate the lawyer says, being wrong about one thing doesn't mean I'm wrong about anything. That's poor reasoning, unless you're perfect. Yeah, give Nate the lawyer a break. And it does, even if I am wrong about this thing, which, I could be wrong. I'm not saying I'm God. I'm not trying to claim like I have some superior interpretation. I just disagree, and I understand why they disagree with me. I just am not persuaded by it right now. I could be wrong. And even if I am wrong, doesn't mean I'm wrong about everything. Give me and Nate a break. Jeez. Flynn pardon was a good thing, yeah. Well, it was a good thing in substance. It was only bad in so much as he really shouldn't have needed it because the whole thing was messed up. But oh man, my hands are really shaking. It's really cold right now. I'm gonna have to go inside because of the coldness. Yeah, Nate Lure says, yeah, we see it as a ceiling. Kurt sees it as a floor. Yeah, exactly right. That's where we're splitting on this. And that's okay. We can have a disagreement. Scalia Morrison. Yeah, there you go. Scalia Morrison. Great opinion. Covered it on my channel. Great opinion. The Great Dissent. Great opinion. Fantastic, Pat. Fantastic opinion. So maybe Scalia would disagree with me. Maybe I need to go reread Morrison, reread the dissent, and consider my position on the Pennsylvania Constitution. Oh man, God, my hands are really shaking. Maybe if I put it down over here or something, braces and something. God, I'm really shaking. What about the Scots interpretation of Bill of Rights applies to states? Would that mean that one can interpret the 10th Amendment applies to states as well? Well, the 10th Amendment by its own terms applies to the states. It by its own terms applies to states. You don't have to incorporate it. It's just already there in the first place. You're saying that when a law is passed, they must list everything. I would disagree. I agree with Kurt that it's a floor. As long as it's not impinged on the Constitution, then fine. Yeah. Yeah. I mean, I'm just looking at the languages there. I mean, if they want to be exclusive, they could have used language to make it exclusive, and they just didn't. You know, there's language that they could have done. It's like, you could have absentees for these reasons and only these reasons, or there's other ways to phrase it, but they just didn't do that. So, you know. Looking cold for Texas. I'm not in Texas. I'm in South Carolina right now, and freezing. The entirety of the Fifth Amendment hasn't been incorporated. That's true, because grand jury clause hasn't been incorporated. Let's see. Chile, it's 50 degrees. It's 21. Yeah, it's, you know. Police power could allow a state to tattoo all of its citizens. In the absence of other things, then probably, but like the police power is the government's power to do stuff, all the things. So are there limitations on that power because of individual rights or individual sovereignty? Sure. But, you know, the police power is the maximum extent of power, I guess would be the way to put it. It's the power to do everything that you have the power to do, which I guess is circular, but yeah, it's power to do anything that is not barred by some other consideration. How about the supremacy clause of the Constitution? Yeah. The supremacy clause of the Constitution says that the Constitution and the treaties and the federal law are supreme to state laws. Right. So if you have a conflict between a state law and a federal law, then as a general rule, the federal law wins, although there are some exceptions to that for other things that are there. But as a general proposition, if you have a conflict between state law and federal law wins because federal law is supreme. So yeah. I just don't think there's any federal law in play that is relevant, but you know, that's what I think. Yeah. I'm on the road, not on my normal stream. I'll be back at my computer tomorrow. 50 degrees chilly, it's a little chilly. My hands are a little cold. All right, cool. I've reached the end of the chat. So nice sliding. This isn't my house, this is my parents' house. But you know, I'm enjoying my vacation. Yeah, so anyways, I'm done for now. I will be back at my normal setup tomorrow afternoon. And I think tomorrow afternoon I'm going to do a stream on the beauty lawsuit between the Not a Crystal Ball and whatever else it was. They're having a fight in the beauty YouTube sphere about defamation or some other bullshit. And I was kind of writing a partial script with this really like dry condescending stuff. So maybe I'll try to write some more of that and actually try to script something out and do this really dry, like insulting commentary thing. So we might give that a shot. But I think I'm going to do a live stream on that tomorrow or film that tomorrow. And then at some point, I still have the New York thing from the Archdiocese with the COVID restrictions to do. I still have to do the Third Circuit opinion to, telling the Giuliani campaign to shut their mouth. That was fun. Still might have to do the Kraken. Still have to cover that. I have so much stuff to do, man. But I have been immobile, and we're just doing as much as we can. Yeah. All right. I've reached the end of the chat. I've tried as best as I can to lay out the constitutional argument as best as I can. And I've pointed out, and I'll point out again because I'm not ashamed to admit it. You know, it's not like I'm ashamed to admit it. That, Nate disagrees with me. Barnes disagrees with me. Nick Riccietta disagrees with me. So, the consensus of the YouTube law commentariat opposes me. And I don't begrudge them their interpretation. I understand it. It's not like I think they're completely off the rails. So if I were writing this as a legal opinion, I'd be like, I respectfully dissent. I just don't read it that way. And the fact that, I'd be being joined with, more likely Democrat judges is kind of neither here nor there, right? Just kind of my interpretation. And I could be wrong. I'm not saying I'm God or anything. I'm just saying this is the way I read it. And I try to explain it why I read it that way. Try to explain the language isn't closed on its own purpose, and try to explain, interpret the U.S. Constitution as limiting because they don't have general police power, and states do have general police power. So, if it doesn't say otherwise, you'd assume they have the power to do stuff, and so forth and so on. So I try to explain my legal reasoning as best I can. And also tried to point out that there's a Senate Bill 413 that's trying to do this by constitutional amendment. So maybe it's because they had to, or maybe it's because they thought it was just important, or even if they thought they had to, maybe they were wrong, and so forth and so on. So I tried to go through the various legal analysis and legal interpretation, and try to show you my thinking along the way, so you can understand where I'm coming from. And maybe you find it persuasive, maybe you don't. That's okay. We don't always have to agree. I just hope that people respect me, that I've thought it through and tried to provide a cohesive rationale, whether that's come right or not. And also hope very much, and I think this is more of a forlorn hope because I think this is more problematic. But I hope that people appreciate and recognize the difference between politics and law. So I think there are a lot of people, not saying anything about anyone in this chat right now, but I think there are a lot of people who want certain outcomes because they want certain political outcomes. They want Trump to win. They want things to be true. So they're looking at this, trying to justify it from an outcome-based perspective, right? So they're looking at the result they want and trying to back end the justification. It seems to me. I'm not trying to back end the justification because I don't want this particular result anyway. I'm just looking at the answer. I'm like, okay, well, here's my legal tools. Here's my legal rationale. This is the result that emerges. Not exactly what I was hoping for, but I can't always have what I want either. So I hope to some degree people attempt to separate their political wishes and policy wishes and hoped for outcomes from what they really think is legally required. And I know that's not the case with Nate. I know that's not the case with Barnes. I know that's not the case with Nick. So I'm not necessarily saying it's the case with anyone in particular. I'm just I hope that you're trying to look at this actually as to what the law is and completely divorcing it from the politics of the situation. At least trying, because I'm trying. Anyways, I gotta sign off. My battery's about to die anyway. Talk to you later. Peace. Bye.